Hello, this is Dr. Michael Arnheim, and this is the first video in a series, but there's no need to watch the whole series right through. You can pick and choose because the whole arrangement is, if you like, modular. That means each individual video stands on its own, and you can be guided by the titles. Now, what I'm going to do in this series is particularly to highlight some problems in English law, and for more on that, you can see my book, my latest book called Anglo-American Law, A Comparison. Anglo-American Law, A Comparison, which is about 500 pages long. And I have to make a disclaimer here that anything I say in these videos and also in the book itself is not legal advice, not to be construed as legal advice. If you want legal advice, you can contact me. I'm a barrister in practice, and my email address will appear on the screen now. So don't hesitate to contact me if you want to, but don't take anything I say here as legal advice. Now, in this video, which is the introductory one, I'm calling Don't Blame the Judges, I want to concentrate on a very important aspect of the law, which for some reason has got into some problems in English law, that is. And that is the area of vicarious liability, which really means a situation where one person is required to accept liability on behalf of another. You might wonder how that could possibly be. Well, actually, it's extremely common and very important. It happens all the time in regard to employment, for example. But it can also apply in cases of agency and in other circumstances as well. I'll just give you an example from a very early case, a lovely little case called Limpus and General Omnibus. Limpus against General Omnibus, 1862. So in other words, when I was still fairly young in practice at the bar. Limpus and General Omnibus. Now, this dates from a time when buses were horse-drawn. There were horse-drawn buses on the streets of London. And as they are today, they were privately owned. The buses belonged to all different companies which competed with one another. And in so doing, buses would get up to all sorts of tricks. Bus drivers would come in close to the curb and splash waiting passengers so that they wouldn't catch a particular bus and they would only catch his bus, which probably had a different bus stop. Or they would actually ram other buses. It was quite fierce competition, and it was well known to the owners of the bus companies. And in this one bus company, General Omnibus, they actually gave cards. They placed a card in the cab of their buses, which said, no racing, no overtaking, and none of this nonsense. They gave very specific instructions to their drivers. Anyhow, on this one occasion, the driver disobeyed that order or totally ignored it. And as a result, this Mr. Limpus was injured. I always like to think of it as a case of where he was injured in his foot and therefore he was limping. But of course, that's not the case, actually. He was injured, and who did he sue? He could have sued the bus driver individually. Yes, he could have. But that would have been pointless because the bus driver probably would have had no money anyway. The bus driver was at fault, there's no doubt about it. But Mr. Limpus didn't choose to sue the driver. He chose to sue the company who employed the driver. Well, the company said in court, said that they had a perfect defense. After all, they had instructed their drivers not to do exactly what it was that the driver in this case had done. Well, how could they be responsible? How could they be legally liable? But the court disagreed with them, and the court found the bus company liable. Now, that was a very sensible decision, really, because had Mr. Limpus gone after the driver individually, personally, he would not, even if he'd won the case, there's very little chance he could have got any money out of him. This way, he was paid damages for his injury because the bus company had money or, of course, probably was insured, and these days would certainly be insured for that sort of thing. That's vicarious liability, where the company employing the driver was held liable for a fault on the part of the driver, which they themselves as a company were not actually guilty of. It's a fault which we call a tort, T-O-R-T, which is from a French word meaning a wrong, from a Latin, which in turn is from a Latin word meaning twisted. It's a civil wrong. Civil wrong. Now, scroll forward to 2020, December 2020, the UK Supreme Court handed down a decision in one of many vicarious liability lawsuits. This one is called Morrison's and Various Claimants. Strange title. Morrison's versus Various Claimants. So called because this was a case brought by hundreds of claimants against Morrison's supermarket. In fact, it was brought by no fewer than 9,263 employees of Morrison's. Over 9,000 of them. But a few cases were taken as sort of sample cases, if you like. And what was this all about? Well, this was a case where someone called Andrew Skelton, who was a senior auditor in Morrison's internal audit team, took all the names, addresses, and personal details of huge number of employees of Morrison's and posted this information on the internet, which of course is contrary to data protection, privacy, breach of confidence, and actually is criminal as well as being a tort. He actually disclosed 126,000 employees' details. 126,000. This included their personal addresses, their phone numbers, national insurance numbers, bank account details, and salary, among other things. So naturally, these employees felt very aggrieved. Well, it didn't take very long to track down where this had come from. This Andrew Skelton was in fact tried, or he was at least charged with crime in this regard, and he was sentenced to 8 years imprisonment. But this case is not against Skelton. This case is against Morrison. You might think, well, why were Morrison's to blame? Well, all these employees felt that Morrison's should carry the can in a case like this on vicarious liability. Vicarious liability. That they should be responsible for these wrong acts done by Andrew Skelton. And the High Court agreed with them. And so did the Court of Appeal. They both agreed that, yes, Morrison's should be responsible. But the UK Supreme Court disagreed. A unanimous Supreme Court found that Morrisons were not vicariously liable. And Lord Reid, who gave the main judgment but with which everyone else agreed, actually put it very strongly by saying the judge, that means the High Court judge, and the Court of Appeal misunderstood the principles governing vicarious liability in a number of relevant respects. We have 2 points there. First of all, misunderstood. This is saying that 4 senior judges, 1 in the High Court and 3 in the Court of Appeal, actually misunderstood. And what did they misunderstand? The principles governing vicarious liability in a number of relevant respects. Well, who was right? The trouble is, the principles are not clear. And this is the problem in the whole area of tort and beyond. In fact, one very senior judge has actually put his finger on this by saying, and this is Lord Neuberger, who has said that he has found disarray, and a marked lack of reliable principle in the field of tort. Disarray and a marked lack of reliable principle in the field of tort. Now, tort is a very, very wide area, a lot wider than just vicarious liability. The main part of it is what we call the tort of negligence. That is huge. That is by far the biggest area of law in the civil courts. And he's saying there's a lack of reliable principle. That ties in with what Lord Reid said in the Morrison case, that the judge and the Court of Appeal misunderstood the principles governing vicarious liability in a number of relevant respects. But what are those principles? Lord Neuberger has put his finger on it by saying that there is a lack of reliable principle in the field of tort. And why is that? That is because the law has been allowed to be decided on a case-by-case basis by the judges. Lord Neuberger, in an interview, as well, that was in a speech that I quoted, but in an interview, he is also on record as appealing to Parliament to give guidance to the judges. And this is what he said. He was talking about the situation after Brexit, but this applies generally, I would say. To blame the judges for making the law when Parliament has failed to do so would be unfair. Don't blame the judges, because it's actually Parliament's job to make law. And that's absolutely crucial, because it is a fundamental principle of the British Constitution, and I would say the bedrock principle of the British Constitution, that Parliament is sovereign, the sovereignty of Parliament, or at least the legislative supremacy of Parliament. And we have seen quite recently just how strong Parliament can be in making legislation and passing legislation. The Coronavirus Act of 2020 is a very good example, because that act imposes great restrictions on individual freedom in the interests of combating this virus, COVID-19. Never before in British history has there been such a strict regimen, such a tight control over the lives of individuals. But that was done by Parliament. Of course, Parliament under the guidance of the executive, of the government. But Parliament agreed to it. Yes, it was rushed through Parliament very quickly, but Parliament agreed. This is Parliament acting in its capacity as the supreme lawgiver. Parliament has complete power to make law. It used to be said that Parliament can do anything except change a man into a woman or a woman into a man. I think even that has changed because Parliament can now do that, even that. But there is no limit on the power of Parliament to make law. And that is really what Lord Neuberger is appealing to here. Therefore, I say with him, don't blame the judges. The fault lies with Parliament for not legislating, for not making laws, laying down principles which the courts are to follow. And, of course, as we know from Newton's science, nature abhors a vacuum. So where there is a vacuum, nature will step in to fill that vacuum, and that's what's happened here. Where there are no principles, or no very clear principles, or what he calls reliable principles, Lord Neuberger, that gap will be filled by the courts. Courts will step into that breach, and you can't blame them for doing so. The fault lies with Parliament. Parliament, that really means the government, should be legislating and laying down principles, not only in tort. It's not the only area where this is a problem. You only need to look across the Atlantic to find that that is what happens over there in America. In America, every single state, and there are 50 states, plus federal law, plus Washington, D.C., in each of these jurisdictions, there is legislation, usually in the form of a code, codified legislation, laying down principles. And that is why the U.S. Chief Justice, John Roberts, has said that the job of a judge is not to make law, but only to decide law that has already decided on the basis of law that has been made by the legislature, either Congress, that is federal legislature, or state legislatures. A judge is like an umpire in a baseball game, parallel he drew. Nobody, he says, nobody ever came to a ball game to see the umpire. And that is absolutely correct. Judges are umpires. They should not be making law. But if the law is not made by the institution that should be making the law, the judges will step into the breach. So it's time that the UK Parliament followed the example of all the American legislatures by stepping up to the plate, as they say in baseball, and making law, legislating principles which are lacking. Don't blame the judges. Thank you. Happy watching. And there are another 5 videos up at the moment, and I'm hoping to put on more as well. And you can contact me directly if you so wish, but anything I said in this video and any other video is not legal advice. Thank you.